Hello, everyone. Hopefully you can see and hear me okay. If there are any issues, please, for those of you who have my email address, just drop me an email and I will obviously look into it because I've got my iPad here so I can see at the same time. My email address for you who don't have it, it's rprasad@spirebarristers.co.uk, and hopefully then you'll be able to send me something. I hope you've all also had the handout for this afternoon. It's quite a long handout, and I'm not going to go through it all because, to be honest, I think I've given you most of the information on the handout. This seminar could go on for 2 hours, 2.5 hours, and I'm just not going to do that. So what we'll do is you can time me. We're going to try and stick to 45 minutes to an hour, and we're going to try and get through as much of this as we can. And as I say, the rest of the information is on the handout as well, if we run short, which hopefully we won't do. So what we're going to look at this afternoon is the issue of inflicted injuries in care proceedings, what needs to be proven, so the local authorities side and what best practice may look like for them, and how to challenge the evidence. So if you're for a parent, if you're for the child or the children, what it is you may need to be doing to challenge what is being said by the local authority. What we'll learn, we'll look at the relevant law relating to these issues. We'll look at how you structure the cases and what best practice can look like. And then we're going to look at how you support the different parties that you might represent. So to get us started, one of the first things I always like to do in this seminar is take us straight back to the basics, because when we refresh our memories on what the basics of the law says, we can also A, bring the law up to speed because there's been more recent cases, and B, we can then look at what best practice may look like on the ground. So to start us all off, you all no doubt will remember the case of X, and there were very strong principles set down by the president at the time. He was just reiterating what was already known in law. But of course, the burden of the proof lies with the local authority. The standard is the balance of probabilities. It's no higher than that. And case law has told us that no matter how serious the allegation, that standard doesn't change. So it's not the more serious the case, the more serious the evidence needs to be, or the more cogent the evidence needs to be. It is the standard. The standard is the same across the board, balance of probabilities. Findings must be based on evidence, including inferences that can be drawn, but not suspicion and speculation. When considering cases of child abuse, the court needs to look at everything as a whole, and we'll come back to that because there's been a recent case on that again. The opinion of the experts is one part of the evidence, an important part, but it is not the full picture. And during this seminar, we will also go through the case law that says that the court can, if it chooses to, disregard or go against, I should say, the opinion of the expert. The evidence of the parents and the carers are really important. The court needs to form some idea of credibility there. And even if the court decides that people have lied for different reasons, the court needs to consider the issue of lies. Mumby also added, of course, that the balance probabilities need to be applied with common sense, that the court may have regard to inherent probabilities, but it doesn't change the balance of probabilities test. And the fact that if someone fails to prove on the balance of a probabilities, fails to prove their defence, that in itself is not enough to say the local authority has established its case. So X was an interesting case from 2015, and for those of you who don't remember the facts, I'll remind you briefly. There were 4 children aged between the ages of 3 and 13, and their parents had separated. In March 2015, the mother and the children, the maternal uncle and the grandmother, were detained at an airport in the UK because they were about to board a flight to Turkey, and what was found on them were ISIS flags, were to-do lists indicating that they were potentially moving over there and not intending to return. So associations with terrorist organizations. The local authorities' threshold pleaded that the mother had no intention of staying in Turkey, that she intended to travel to Syria with the children, so travel on from Turkey, that she was going to join up with ISIS militants and supply them with items that they could use to fight, and that the local authority was saying, as a result of the mother doing that, she was taking the children to a war zone, and she was placing them intentionally at risk of significant harm. The mother's story wasn't great. So credibility, in essence, was dashed with this mother because her story changed several times. One time she said she was going to Turkey for a holiday. Then she said, I won't resist the findings being sought by the local authority. Then she changed her mind again and said that actually she was going to Turkey and then to Syria to marry a man. So it wasn't to necessarily get involved in the conflict. Munby heard the evidence and he decided actually the mother is a liar. There's no doubt about it. She had no credibility whatsoever. But that in itself could not establish the local authority's case. Regardless of how implausible her story was, it was still on the local authority to prove its case. And he didn't feel that they had made the necessary links between just finding these items and drawing conclusions that she was going to Syria, that she was going to meet up with ISIS militants, that she was going to supply them with equipment. Whilst we might suspect that that's what the case was, he didn't feel that that was enough, and he dismissed those proceedings altogether. So it's quite useful to take us back sometimes, just to go straight back to the basics of things. And what I like you to think about, just arising from that very basic summary of the law, is some practical tips that we should consider and think about. The first thing is that the local authority, I think, should never take for granted that findings will be made. In these types of cases, local authorities often think because the experts filed a report and is with us, because the injury is suspicious, the judge will be with us. And the reality is that doesn't always happen. You still have to gather your evidence. You still have to, for instance, and this is my list for you as suggestions if you represent the local authority, complete family assessments, child and family assessments, interim parenting assessments, single assessments, whatever you want to call it. You must complete assessments to understand the context of the family. Often we get cases where the local authority have not been involved with the family at all. And if they aren't involved, they have no idea about what the situation has been on the ground. An assessment before a finding of fact hearing, if, for instance, there is a finding of fact hearing, can be really useful to help you to unpick and understand the context of the family, the background of what's been going on. The other useful thing that I would consider that the local authority needs to be mindful of at all times is when the minute a case like this lands on your desk, you need to be thinking about, well, what professionals on the ground have been involved with this family? If the local authority hasn't, often, for instance, health visitors are, nurses, GPs. Do you need the records? Do you need the statements from them to outline their involvement? Because that in itself can be telling. Simple things like mother reports to the health visitor, I'm struggling, I don't know, I'm nervous, I'm not getting much sleep, can be so significant when it comes to a child with an arm injury, some broken bones, and you're wondering, well, how has this been caused? Who could have done this? Those little snippets of information that the health visitor gathered can be really important. Sometimes if we have suspicions around substances, then substance testing reports can be useful. If we have issues around mental health, psychological and psychiatric assessments can give us a better idea of how someone is functioning, what their bond has been like with the children, their understanding of risk and their ability to protect. And of course, viabilities. People forget sometimes when they prepare these cases that viabilities can be useful because what the family see, if the local authority hasn't been involved, can be quite useful. We know about police disclosure and the importance to getting that, but sometimes what can often slip through the cracks are other forms of disclosure. So for instance, if there have been previous proceedings many years earlier in relation to other children, sometimes we can obtain those, or sometimes we get the disclosure order and then we struggle to find those papers and we give up. Actually, previous proceedings can be quite telling around behaviors, ways that people conduct themselves, showing that someone might have an anger issue over a longer period of time. And so we should always remember to gather that information. Likewise, sometimes what we forget is that we live in an age of technology, and mobile phone disclosure is one of the most telling things that I see in cases, and often cases can turn on when you're looking to identify a perpetrator, who sent what messages and what was the context at the time. I recently had a case where, and we get these often, and I call them the squeaky clean parents, the parents who, but for the injuries, are otherwise decent parents or otherwise able to look after the child. That's what the evidence tells us. And we had mobile phone analysis in that case, and in a case of mine of that nature. And before the mobile phone analysis came in, it was very much, have these parents actually done anything? They seem to be the kind of people who have been getting along absolutely fine. Then the mobile phone analysis came in, and we discovered that actually mother was really struggling with the care of the child. She'd made comments about hating the child. She'd made comments about wanting to throw the child against the wall when the child was crying at night. And father had made comments in his messages and had even Googled wanting to put the child up for adoption because they couldn't cope with the sleepless nights. That was very telling because on the face of it, when we had squeaky clean parents, you could never get a sense that that's what was going on. So I always say to people, if you read a case that lands on your desk and you think, actually, they were texting at the hospital, or they were texting days before, or dad says he's at work, but mum would text him often about how things were, get those messages, apply for mobile phone analysis, and see what is there. Likewise, if someone ends up in prison, and there have been telephone calls to prison, there has been communication, often that record, or those records themselves, can be quite telling and useful in terms of what people have been said. Prisons often don't take issue with providing that, as long as you get an order from the court that the recordings, the telephone conversations can be disclosed, they will often disclose them. The only caveat to that is they can be hours and hours, and transcribing them can be very costly. So I would say to the local authorities, just be conscious of that. It has to be relevant. It has to be that you can see that there might be something that arises out of this that would be useful before you embark on that. The reason I flag all of that right now and at the start of this seminar is because, of course, we have to remember the issue of delay. If you don't pre-plan these cases and front load the evidence gathering job, you may find that when finding of fact hearings are listed or composite hearings are listed, and you then come in and think, oh gosh, all this evidence is missing, oh, we need to go get this, that the court is very unsympathetic. And they say, no, because of delay, that's it, you've had your chance, you should have flagged it earlier. I think these issues are the kind of things that need to be dealt with quite quickly, quite early on in the case, for many reasons. One is delay, two, memory fade. And it is an opportunity for the local authority to make sure it gets the ducks in a row. If you are for the parents, I always say to lawyers working on that side of the fence, when these cases arise, one of the real things that surround the parents, the carers, is this element of suspicion. Have they done something? Something doesn't feel right. And the smell in the case is often the parents aren't saying something. And I think, as an advocate, that the greatest tool that a parent has is to be as detailed and forthcoming with information at the start. The initial statement giving the court everything from the moment that child was born, how you felt about that child, any issues that were in the relationship, how the care of the child has been, whether the child's been crying or been difficult or not. Give the court as much information as you can early on in that statement, because when it comes to the finding of fact hearing, credibility will be everything, and any information missing will no doubt go down as this parent, who we already suspect is doing something dodgy, has withheld information. And so even if it's not the prettiest of information, the one thing a parent may have is credibility. The one thing a parent should try to maintain, because if they're going to work afterwards with any findings, they need it, is credibility. So give as much information as you can early on. Often parents will try their best to do that, but then a week later, a month later, 2 hearings later, something else is mentioned and they say, oh, I didn't realize I had to say that. And if you represent parents, I know this feeling, because you often think, I think they're telling the truth about that, and they just didn't realize that that was important. But you also know, as a lawyer, when that will be presented, it might look as though credibility has been hit. My view on this as a practitioner is, the moment you realize that there is more information that needs to be before the court, file an addendum statement, ask for permission and file an addendum statement, and have the parent explain in it, I didn't realize this was important, or I've only just thought about this, or I didn't say it before for X reason. Again, it is important for the purposes of credibility that those issues are flagged early on. I would also say that is something to be very mindful of if you have clients with learning difficulties and disabilities, because they often will not, despite the best endeavors of the lawyers and them, be able to give the full story. And it's important that we flag that early on to the court and say, I'm conscious my client has this learning difficulty. We've tried to be as detailed as we possibly can. If anything arises, we will file addendum statements, but we don't want the court to think that this is something that my client has purposely withheld, because of course they do have learning difficulties, they do have learning disabilities. Often judges are sympathetic to that. Establish a clear chronology. So when the evidence comes in, I always think, whether you're for the local authority or the guardian or the parents, create a chronology. Try and get a sense of what has gone on with the family. If you can't do that, it means there is missing evidence. If there is something missing, some conversation, some date and what happened on that date, some snippet somewhere that you haven't got full clarity on, it probably tells you that you're missing a bit of evidence. And that's quite useful to know in itself. So moving on with the basics of the law, we know that improbable events can happen all the time, but they don't necessarily reverse the burden of proof. They don't change the standard, which is balance of probabilities. The one thing I do want to really talk to you about is primary evidence, because sadly we still live in a situation where often what happens is the local authority will present the case, but a lot of it will be hearsay evidence. So Re-A is the big case on that. For those of you who already know, please humour me on this. I always make a point about this one because it's so important. Re-A involved a case with a baby who was born in prison. Well, mum was in prison when the baby was born. Pre-birth assessments had not identified family who could care for this child. And ultimately, the child ended up being Section 20'd and placed in foster care. The local authority took 8 months to issue proceedings, 8 months in respect of a newborn baby. The president at the time, Mumby, described it as shocking, unexplained, and an abuse of Section 20. At the final hearing, Mum initially sought to care and father sought to care, but then by the time of the final hearing, Mum was not putting herself forward. Local authority and guardian wanted the child adopted. They were supporting placement orders. The guardian had only met with dad, though, once for 45 minutes, bearing in mind dad was seeking to care. And the analysis prepared by the guardian was largely based on the local authority's evidence and what they had put forward. Father put himself forward to care with the assistance of his mother. So what then happened? Well, the reality is the case crumbled and this child was able to go back to dad. What the president said was this. He reminded us of the importance of proper evidence. He criticized, the social worker, he criticized the social worker because the social worker had criticized dad. Because, listen to this, dad had said he'd been involved, he had seen, not been involved, he'd seen a fatal accident on a railway, which had left him struggling sometimes emotionally and had caused him difficulties. The social worker said he lied about this. He appears to have lied about this, which is that he witnessed the fatal accident on the railway. And the reason she said that was because there was no police record of him reporting that he'd seen a fatal accident. Now, Mumby made the right point, which is, why would anyone who just witnesses an accident necessarily report that to the police? And why would the police make a name of every single person who has witnessed an accident? Dad may well have witnessed an accident and the police just doesn't keep a record. It doesn't automatically follow that he's lied about it. The social worker also called dad immoral for having sex with a 13-year-old when he was 17, but she hadn't provided any proper evidence to explain, now that he was much older, how there was still a presenting risk. The social worker had criticised dad for being a member of the English Defence League, which a judge said not in itself enough for issuing care proceedings. And the social worker wrote in her final sweat that dad had numerous convictions. In fact, what he had was allegations, and he'd only had minor cautions. But she had construed allegations with convictions. And again, she criticised him for using cannabis when there was no evidence that cannabis was an actual risk in the case. And we know that cannabis, we have to show how cannabis influences care. We can't just say it. Mumby says, and I quote, "The present case is an object lesson in almost a textbook example of how not to embark upon and pursue a care case." So it's quite relevant for the local authority and for the parents, if you wish to criticise the local authority, to be aware of this case and to understand that the primary evidence is very important, because in this case, once we had the primary evidence, Mumby did not feel that the local authority was able to make out its case. Where does that leave you? Well, gather relevant statements in the proper format. What I mean by that is Children Act statements. Local authorities often just rely on a handwritten note that they file somewhere in the bundle. Local authorities often rely on the social worker saying, the nurse told me X, Y, Z, or the school teacher told me X, Y, Z. That is hearsay evidence, and you need to get proper Children Act statements from those people who you rely on, including police statements. Police statements are not actually Children Act statements. They're technically hearsay evidence. And if you want to rely on something that an officer says, you should get it in a proper Children Act format. Even if it's just a statement that says, I am PC so-and-so, I have read this police statement that I prepared on, or this Criminal Justice Act statement that I prepared on X date. It is exhibited to this statement as Exhibit A. I have reread it, and it's true to the best of my knowledge and belief. That then turns it into a Children Act statement. But you need that. For the purposes of formality, you need that. social workers who spoke to the family. Often what happens is when we have inflicted injuries and cases of injuries to children, we do the Section 47 investigation. We can have several professionals having spoken to the children, and the initial sweat that comes in will say, so-and-so told the social worker this, so-and-so told the social worker this, so-and-so mentioned this, and it's very unclear which social worker has been told what was the conversation, and what was the context of it. That will fall apart at a finding of fact hearing or a composite final. And so every bit of evidence that you rely on in terms of what was said and by whom, you need to gather that from the person speaking in a proper Children Act statement. It is not enough to have one social worker echo the words of another one. That won't work. Okay. So we've got that. Let's talk about the other element from this, which is getting evidence from children. Now, this could be a seminar in itself, but of course, I'll briefly recap. When children make allegations, we have to follow the guidance in the Orkney and the Cleveland reports. These were reports prepared by Dame Butler Sloss back in the day on the back of the Rotherham sex scandals. And what she had done was provide comprehensive guidance of how the evidence should be obtained from children. There's been a lot of case law since that endorses A, that ABE interviews and the ABE procedure is entirely appropriate and relevant, and B, if good practice is not followed, then it can discredit what children says to the point where the court cannot rely on it. Remember, even if the parent is deemed to be incredible, the local authority still has the burden to prove, and so they need to put reliable evidence before the court. Very quick recap from what the reports told us. They told us that social workers have an investigative role. They should not be taking sides. They should listen to what children say and write it down. They should not lead children into saying things. If a question is asked of a child, which then leads to an allegation, we write the question down, we pass it on. We pass it on to the police, who can investigate it properly in line with proper ABE guidance. We keep accurate records, contemporaneous records of what was said by whom. So I don't just mean the child said this. I mean, what question was asked of the child, exactly verbatim. What were the exact verbatim words that this child used in response? How were they presenting? Who was in the room? What was their manner like? All of that is incredibly important, and we have to make sure we write these things down in the note, which can then be relied upon. So accurate record keeping is incredibly important. And of course, the ABE interviews, full transcripts of police interviews, they can all assist to ensure that the evidence is there before the court. The binary system, we're aware of that, and we're aware that actually there is no room for something might have happened. So I raised this one not to teach you how to suck eggs, but principally to deal with the issue of threshold. Often when threshold is drafted, and again, threshold could be a seminar in itself, but often when threshold is drafted, we have to be careful to make sure we actually plead the allegation. So the appears to have lied, someone appears to have lied, is not a threshold allegation. The allegation is John has lied. It's not John appears to have lied. The allegation is not the children have said that their father hit them. The allegation is the father has hit the children, because you are not proving that the children said it. You're trying to prove that the father did it. And so there's useful case law on this. Re-A, again, 2015, EWFC 11, Mumby deals with it, the case we just discussed. I would also invite you to consider Re-B, a child, 2013, UKSC 33, which is Baroness Hale going back to the very basics of threshold and saying what you need to do is identify precisely as possible the exact nature of the harm. We have to make sure it's significant, and we have to attribute it to something the parents do. So cannabis is a good example for this, because what we find is a lot of people allege cannabis, and it's always a concern for social services, but they haven't linked it to, well, what's the actual harm to the child? Just be conscious of that. The reason I flag that is because, as we know from the binary system, it either happened or it didn't. And if you're not pleading it properly to justify that it happened, then you might find that the court is unable to make those findings or is critical of the local authority for the way they put it. Let's turn to some of the law that is specific to inflicted injuries or cases of injuries to children. The case of Lancashire Nara is very useful because that was a case where Mustard made it very clear that there is no pseudo burden on the parent to come up with an alternative explanation. Often what we see is in cases the local authority will say, well, they haven't said how it's happened, or, well, we need to know precisely what they've said. And because a parent can't provide that, they assume that the parent must have done something more sinister to the child. That is not what the law says. In fact, parents often can't account for injuries. That in itself does not mean that they're guilty. The local authority still has to prove their case. What this case involved, the Lancashire case, was a 3-month-old child who had sustained a serious head injury, and they'd sustained it at home. They had subdural bleeding and retinal hemorrhages, classical signs for a shake. She also had a scratch to her eye and an abrasion to her chin. Father claimed that he tripped and he fell while he was holding the child, but the local authority didn't accept that explanation. Some of the medical evidence indicated that this was potentially an assault, so they didn't fully accept what the father had said. The local authority put forward evidence that because the father had previous convictions for prior assaults and he'd assaulted the mother, that actually he probably lost his temper and had injured the child. The consultant pediatric ophthalmologist maintained that the father's explanation for the injuries was unlikely, but he did say under cross-examination he couldn't exclude that what the father described, which is the tripping and falling, could have caused the injury. What the Mostyn looked at and considered in that case was this: if the parents come up with an explanation, it is on the local authority to disprove it. Actually, there's no burden on a parent to give an explanation. The local authority still has to prove. But if they do come up with an explanation, it is on the local authority to disprove it. So they don't have to prove that what they say has caused the injuries. The local authority has to disprove what they've said. And that is very important, because if you are representing the local authority, well, if you're representing a parent, you want to be very alive to this law. But if you're representing a local authority, you want to be very much alive to, if an explanation comes forward, it's up to you to show that that cannot account for the injuries. So that's important for you to know. The evidence of the parents, the carers of utmost importance from Re W, which we know, and the Court of Appeal in Re C. I remember this case. So this was a case last year. Yeah, it was. Re C is a case from last year. And we had a child. It's on the handout later on, I think. I give you more details of this case. AB interviewed. Child makes allegations against the father. Application made for the child to come and give evidence, and the court decided, I don't need that. I don't need to hear from the child. And father decides, well, I'm not, if she doesn't have to come to court to give evidence, I'm not coming to give evidence. And then didn't give evidence. And of course, findings were made against him. He then tried to appeal it, and the Court of Appeal was just not entertaining any of it, and took the view that actually, if he chooses not to attend, that's on him. It was entirely appropriate for the trial judge to draw inferences in that case that he is likely to have caused the injuries. And that is different, because that is to do with whether in fact a parent attends a hearing to defend themselves. Now, that is different to if a parent, say, put forward an explanation which has to be then disproved by the local authority. Lies. So we'll move on to lies. You all know about Lucas, I'm sure. You know that people can lie for many reasons. And so the reason I included Lucas on this, I've given you a lot of law on it on the handout, but I wanted to bring you up to date with the law in terms of A, B, and C, the 2021 case. More recently, Lady Justice Macker gave a judgment about lies and tried to deal with this issue again. What she does in that case is she looks at it and she basically quotes from the Crown Prosecution Compendium, which is the book that is used for criminal judges to warn the jury about Lucas lies. It gives them some guidance on that. And what that compendium says, and I'll read it to you, it says, a defendant's lie, whether made before the trial or in the course of evidence or both, may be probative of guilt. A lie, however, is only capable of supporting is only capable of supporting other evidence against the defendant if the jury is sure that, 1, it is shown by other evidence in the case to be deliberately untruthful, 2, it relates to a significant issue, and 3, it was not told for a reason advanced by the defendant or from other reasons arising from evidence, which then points to his guilt. So what we take from that, and what Macker J took from that, is she said that actually when you're going to have these cases, or when you're going to be saying a parent has lied, and you have to direct the judge to the Lucas direction as to why people have lied, if the local authority will be saying, actually, they've lied because they're guilty, there's no other explanation, that's why they've lied, guilt, then the local authority should do, good practice, should look like this. The court should seek counsel's submissions to identify, one, whether the deliberate lie upon which they seek, let me restart. The court should invite counsel, and so it's useful for all lawyers to know, to identify the lie which they seek to rely on. Two, to say why it is significant. What reason do you say it's significant for the court to consider? And three, on what basis it can be determined that the only explanation for the lie is guilt. So perhaps what used to be a more standard, he's lied, therefore you can't trust what he's saying, has become a little bit more complex. And Makor LJ is now saying, look, the local authority, the party who has to prove this, has to be a little bit clearer about things. They have to tell me, what is a lie? Why is it significant? And how do I get to the point where I can find the only reason the lie has been told is to find that they're guilty? And she takes that from the Crown Court Compendium and feels that the criminal courts, because they practice in this way, their procedure should be implemented in the family court. So I flag that for everyone to see, because particularly if you're for the local authority, you want to be alive, that's how you need to frame it. If you're for a parent, you want to make sure that if the local authority does turn around and say, your client is lying, flag this to them. What lie is it you're relying on? Why is it significant? Why do you say that the only reason they've lied is because they're guilty? Put the burden on the local authority and put them to work for what they need to be proving. Memory, we know about memory. We know that memory is unreliable. As time goes on, it fades. We know that people can say things with lots of passion, and even though they're saying it with lots of passion, it might be something that they're remembering wrong. We know that there's the issue of what's called story creep, where they're sort of filling in gaps as they're trying to iron out things that have happened when the memory's fading. And all of that is important, particularly when an explanation will come late in the day, or if more information will come tonight and a parent will be asked to clarify further issues. You want to be able to flag these issues and be able to say, actually, it might not be that my client is lying about these things. It might simply be that this incident happened a year ago, and you're now asking them to clarify on X date what exactly they did, which is hard to do. And that is an important point to be making to the court. I think it's also important with memory to flag it for clients with learning difficulties, because often we see in the cognitive reports, and sometimes the capacity reports if we get them, that clients will have issues with working memory and processing information. You want to flag that when it comes to the issue, because if the court will then be invited to look at credibility and to say, as the other case ABC told us, that they've lied deliberately, and they've lied because they're guilty, then you want to be able to flag this to say, actually, on the other side of the coin, you do have someone with memory issues. You must consider, when you will decide if they're lying and why they're lying, is it actually a lie or is it a memory issue? And even if it is a lie, is it deliberate when in fact they have all these difficulties? So that's something worth remembering, something worth flagging again for everyone to know. Identifying a perpetrator then. You've come to care proceedings, you are, local authorities put two people in the pool, let's say, they're blaming mum and dad for being responsible for the injuries. And one has to know and recognise, well, how does the court get to the bottom of who's done what? There's been a lot of law on this, and I've set it out in your handouts for you. I'll give you the overview of it. In summary, there used to be situations where sadly things went wrong, and the law was clarified, particularly in Re B, where it was decided by Peter Jackson and laid out that actually what the court needs to do is to look at the totality of the evidence and decide on the real possibility test. What it needs to be able to say is, is there a real possibility that mom could have injured the child? Is there a real possibility that dad could have injured the child? Is there a real possibility that, for instance, granny could have injured the child, whoever's in the pool, so to speak, or the local authority puts forward in the pool? If the judge then thinks there is enough evidence to say that there is a real possibility that that person could have injured the child, the next step after that is to then go from these people who I've identified could have injured this child, i.e. from the people who pass or fail, if you want to put it like that, the real possibility test. Can I identify the perpetrator? And it's not who is more likely to have done it out of this lot. It is there enough evidence that I can confidently identify on the balance of probabilities out of the people I have now put in the pool who the perpetrator is? And if there isn't that evidence, then the judge should keep it at a pool finding. The judge should say, I believe there's a real possibility all these people have injured the child or could have injured the child. I can't identify the perpetrator from the pool. And so that's what the law tells us about how this should be applied. There must be evidence before someone goes into a pool. Now, I will pause here and explain what I mean by that. Often local authorities will say, mum's had care, dad's had care, and granny had the child for an hour last Saturday, so all three of them in the pool. Actually, it's not that simple, particularly for granny. Granny may be the kind of person who has a positive viability, who's had 6 children, never had social services involvement, no criminal record, holds down a functioning job, all the hallmarks to suggest that actually she's not the kind of person to have injured a child. And the local authority sticks her in simply because of opportunity alone, which is that she had the child for an hour on the Saturday. Well, firstly, you want to check what window the experts give you. When you will appoint experts to comment on who has injured this child, well, not who has injured the child, when this child has been injured and the nature of the injury, when you will appoint experts to consider those issues, they often come back with a time frame. Unless it's bruising, you can't bruise time. You can't date bruising. If they come back and say, for instance, the first injury happened when the child was 3 weeks old. The second injury happened when the child was around 7 weeks old. And this is me generalizing entirely, just for the sake of giving you an example. It doesn't really work that neatly. Then if granny had care in week 7, but not in week 3, and the child's got 2 injuries, it's very unlikely that granny's caused that injury because, of course, granny's been only around for one of the injuries. Now, that is part and parcel of the inherent probabilities, and it is something the court will have to consider. And I always say to local authorities, just be mindful that your test is a balance of probabilities. It's a much lower standard. And if you can only say that notwithstanding this fact this child's had 2 injuries, granny could only be responsible for one of them because of time window, then you have to consider seriously, is there anything else to suggest that granny is the kind of person to injure a child? Because if you don't have that other than opportunity, i.e. the 1 hour on the Saturday, she may not be someone you wish to put in the pool. I always think as well the parents have a role to play in this because they need to clarify, do they put granny in the pool? If the parents say, no, we don't actively point the finger at granny, and neither parent is doing that, then I would be advising the local authority to not put granny in the pool. That actually it's more likely that one of the parents have done this on the balance of probabilities. So there's a careful balancing exercise when the local authority will plead the case, to make sure that they only include people who actually they have evidence to show could have injured a child, i.e. could satisfy the real possibility test in terms of injuring a child. If you have been brought in on behalf of the intervener, or if you're a parent and you find that you've been put in a potential pool by the local authority and all they have is opportunity, you want to be flagging that to the judge. You might want to ask the judge to make a preliminary determination on whether in fact you should be an intervener. Because if the local authority puts you in the pool, even if the local authority points the finger at you, ultimately, whether or not you should be there is a matter for the judge to consider. And if prima facie the authority hasn't got the evidence, you can challenge that and you can raise that with the judge and have an argument on submissions about it. So that's something worth knowing and worth flagging. So if you go through that process, the local authority gathers this evidence wonderfully and manages to get its findings. Where does that leave a parent? Where does that leave you in terms of seeking to care in the long term? Now, there are some injuries to children which are so horrific that it's game over. And I think we all know those kinds of cases. So, for instance, serious sexual abuse, if findings have been made of that nature against someone, it's probably game over in terms of caring. It's only very rare cases that would be otherwise. However, it's more nuanced and subtle than that. If, for instance, this is a newborn baby with parents who are otherwise not known to social services, hold down stable jobs, no concerns over mental health, no concerns over drug and alcohol use. They have simply struggled in the moment of caring for this child when they've had colic in the first few weeks of their life, when they've been very difficult and ended up injuring this child. And what's happened is either a perpetrator finding has been made or a pool finding has been made. Where do you go from that? Well, local authorities will often say, well, that's it. They can't care for the child. They haven't been fully honest about it. The judge had to make a finding. And if they're not fully honest, you can't safeguard. That is an argument that I think is used way too often unfairly to parents, because the reality of risk assessments, and in particular what any forensic risk psychologist will say to you, is you don't need people to fully give you the details of what's gone on. As long as they accept that they are responsible, or as long as they accept that they could be in a pool as someone who is responsible and understands what that means, they could be worked with. So, for instance, the resolutions model is something I flagged, and I always bang the drum about. For those of you who don't know, Jay is a very useful case where a circuit judge decided that because resolutions work so well in his case, he would publish a judgment about it. So it doesn't have the weight of authority coming from a higher court, but it is a very useful example to put before the court to say, look, this does work. In that case, what happened was this. There was bruising to a child. Both adults were in the pool, so a pool finding was made. And an independent social worker was brought in to do a resolutions model assessment. Now, what a resolutions assessment does is it looks at people to say, okay, this has happened. You accept that something's happened, even if you're not giving us the specifics of what's happened. And the reality is that we now have to think about, have things moved on? Why did you end up in a situation, regardless of what that situation might have looked like, that you ended up injuring a child? Was it because the child had colic and was crying and was a newborn baby and was very difficult? Were you learning to be a parent? All the stresses and strains that came with that, were they other stresses and strains still an issue now? Has the situation moved on? Is the child 1 now or 2 now and not going through that same level of difficulty? Do you have a new partner who could be a safeguarding feature? Is there family that could be around to protect and safeguard and keep a watchful eye? And resolutions basically says, just because findings have been made, it's not game over. You can have another bite of this cherry. We need to look at the situation then to understand what the triggers were and the difficulties were. We need to look at the situation now to see if we've moved on, to see if, for instance, we've had some acceptance of bad behaviors and misconduct, to see if they're a family who could safeguard, and parents who are willing to work with professionals. We can then do work with them to ensure that they understand what has gone wrong and how they can reach out for support again in future. And we can try to rehab the child back to the family with initially 100% supervision by family and friends, for instance, and then slowly working our way down to a situation where the family can then be left on their own and move on from this situation. Resolutions is useful, it is powerful, it helps families in cases with inflicted injuries be able to move on and reunite with their children. And it's certainly something I would suggest that you're all aware of. I always say, to make sure this works, if you identify a case where you think, gosh, resolutions might be a good option here, then please, from the very beginning, flag to the local authority that need to explore the support network in the family to identify the kind of people who could provide support in the long term if findings are made against your client. Regardless of if they're saying they're innocent or guilty, get the local authority to do that work early. Highlight resolutions early to the local authority so they know that you're coming with this, and they can then address when findings are made in a statement. You can ask the judge to deal with this. Say, I would like the local authority to file a statement as to what their next steps are now findings have been made, and in particular, whether they have considered the resolutions model to look at rehabilitation of the family and why they may rule that out. If they rule it out, ISWs do this all the time. Get an ISW forward. Local authorities and guardians, in my experience, tend to be very hesitant about this. If you're for the guardian, of course, advise her about this. Show her the case of Jay and how successful it can be, or him, and bring them along. If you're for the local authority, do your best. They don't always like this particular model, but the court is sympathetic. More and more, the court is sympathetic to parents who the court can see have made mistakes under pressure, are trying to work with professionals, and are trying to do better. So on the handout that I sent you, you actually have the link to this case. So please do have a look at it. Hopefully it will help you to move matters forward. One final thing I will say about resolutions is you will hear an argument, perhaps more so now that the president is so concerned about delay, that in fact resolutions is like a 16-week assessment. It will take a very long time. We haven't got time for it. Just remember that the case of Re-S, a child, 2014, EWCC B44 FAM, a case with Miss Justice Mumby as the president at the time, had identified that whilst 26 weeks are very important, there are those cases where we have to accept inevitable delay. And one of those, he gave 4 examples, and he said 4 examples readily spring to mind. One of them are very heavy cases involving the most complex medical evidence where a separate finding of fact hearing is directed. His view was that those type of cases do involve extensions, do involve a certain level of delay. And if you need to flag that for your client, for them to have the opportunity of a resolutions model assessment and reunification to be considered, don't be afraid to do it. Use that case. That's my go-to if I want to say delay is necessary. and now you all know it. You'll all use it as well. Okay, failure to protect. So if you're for the local authority, one of the things that you want to consider when you plead these types of cases is that when a child has been injured, you might instantly think, well, we can say mom or dad's done it and the other one's failed to protect. And once upon a time, that would have been enough, but not anymore. From the case of LW, Eleanor King, Lady Justice King, warns us of the dangers of what she's called a bolt-on finding of failure to protect. It cannot be assumed that just because you live in the same household as a perpetrator, that you knew that person could have injured a child and you failed to protect. So what was this case about? Well, there were 4 adults in the potential pool of perpetrators in this case. Mom, her partner, dad and his partner. The judge found that mom's partner had injured the child, and he found mom had failed to protect because she'd failed to ask her partner what had happened when she was at work, and she'd not listened to her own mother, so Granny, saying that the child was frightened of mom's partner. The Court of Appeal looked at that issue because the failure to protect finding was appealed, and they overturned it, and they said that that is not enough. The fact that she didn't ask her partner what happened, and the fact that she had been warned by her own mother that the child was frightened of him and didn't do anything about it, is not enough to say that she knew that this man could have injured a child so significantly to cause to cross threshold that kind of serious injury. Actually, just because you're the kind of person who loses your temper and might be violent with adults, because he was violent with her in the past, and in adult situations, should not necessarily alert people that you are the kind of person who would hurt a child significantly. And so if the local authority wish to now claim failure to protect, they need to particularize it and justify it better. The standard you were in the house is not going to cut it. So I say to local authorities, plead it properly. Actually, if you have the evidence, when you plead threshold, you will say, as we always do, this is an inflicted injury caused by this person or that person. Mother, if it was father, mother failed to protect because, don't just leave it as failed to protect, because, and say, she knew father had a temper. She knew father had lost his temper with the child. She had seen the child distressed by it. She'd seen father hit the child on one occasion. She knew father was therefore capable of hurting the child, and she left father alone with the child. That's how you plead it. And you have to be very clear exactly upon what basis you put a failure to protect finding on the back of LW. If you're for the local authority, make sure you do, because you can be criticised for this. And ultimately, if you don't plead it properly, the parents might have the ability to appeal on it, because they might say, we didn't know the local authority's case. How could we defend it if we didn't know what it was? If you are for a parent, concede a failure to protect early. A failure to protect is not the hill to die on. If you have been accused of a failure to protect and you realise, actually, there's merit in this, that if he did it, I have failed to protect, concede that early, because there is lots of work that can be done with parents whilst you await a finding of fact hearing, for instance, to bring them on board, to help them to learn how to protect better in future. If you wait until the finding of fact hearing and die on that hill, then it might be too late to get that work done. And that might be enough to rule your client out as a long-term carer. So I always say concede it early, it shows insight, and ask the local authority to then do work with you, which means that by the time of the finding of fact hearing and or composite hearing and or welfare hearing, you can stand up and say, I recognise that very early on, I worked on my bad behaviours and I've had work and I'm better now. So that's failure to protect in a nutshell. Let's move on. I'm conscious of time. I said I'd be done and I've got about 10 minutes, haven't I? Experts. Now, I'm not going to spend a lot of time of this. I've given you the case law on the slides. We know that expert evidence, whilst important, is not everything. Local authorities often can become complacent and rely on the expert without gathering the wider evidence. So I hope what we covered earlier will assist those who represent local authorities to be conscious that the expert evidence is not enough to get you over the line. You do need to gather other evidence. Be conscious that there are overly dogmatic experts who will go too far in their report and be willing to recognise that. Be conscious that the court may even find that there are unknown causes to things, or that the court may decide, I don't agree with what the expert's saying. So I'll give you an example of that. I had a case where there were fractured ribs, and the mother had described a situation where she'd thrown the baby up and catch the baby. And on everyone's account, it was a very unsafe thing to do because this baby was like 3 weeks old. But she did have learning difficulties and perhaps didn't realize what she was doing. The experts had come back and said, I think that's unlikely. I don't think that that could account for an issue, for the injury to the child. Under cross-examination, though, they had accepted, when they had seen the description of what was done, that actually if you throw a child and catch the child, you're gripping with more force because you're catching the child. It's not like holding the child while the child's walking. You're catching the child to prevent them dropping, and you could have caused these injuries. They didn't think that it was probable, but they could see that it was possible. And in a case where there were otherwise no concerns in respect of the children, the judge sided with the parents and decided, I will accept that explanation, because the local authority had not proven otherwise, that in fact, the local authority had not disproved the explanation just because the expert had said that. They needed to be more around this to show that these parents were the kind of parents who would have injured this child in another way. And frankly, they simply weren't those parents. Threshold was still crossed because what the mother did was still threshold in itself, but it was not as sinister as perhaps one would have initially thought. So just be conscious of that, and be conscious of when experts' reports come in, if, for instance, an expert is saying, I actually think the parents might be right and it could have happened like that, and you have nothing else, i.e. no propensity to injure a child, no sort of history of neglect or anything like that to say, this could have been something more sinister, there might have to be the cases where you withdraw. So I've put there, don't exclude the possibility of having to withdraw. It's about being reasonable, I always think, working with families. If you have a case where parents are the kind of parents who can be worked with, the kind of parents who are otherwise going to get a positive assessment but for the injury, and you have an expert that comes back and says, I can see this explanation accounting for the injury, or whilst unusual, it may account for the injury, do not die on that hill. It is better for the family and for social care for them to work with that family to move past that than to fight that in court when you don't have the evidence and ultimately lose. If you ever need the test for when to withdraw proceedings, just write this down. It's Family Procedure Rules 29.42. A local authority can only withdraw with the permission of the court. You can look at the case of GC v. A County Council and others, 2020, EWCA Civ 848. And in essence, a local authority can withdraw with the permission of court in 2 instances. On an application for a care order, the local authority will be unable to satisfy the threshold criteria, and therefore it must withdraw, and then their application will succeed. If you can't meet threshold, the court will give you permission. Or the other criteria is this: the local authority could satisfy the threshold criteria, but that the proceeding should be withdrawn anyway because it would not promote or it would conflict with the child's welfare and the overriding objective. And so just be conscious of that. That is your case law if you needed to withdraw proceedings. Let's move on to, so choice of experts. I've given you some tips there. Choose your experts wisely. There are those experts, sadly, in my experience, that I think can be very dogmatic and I've seen so many expert reports where some experts, not all, some experts have very clearly just copied and pasted from other cases, and where you can tell that they churn out the same report over and over because you see the same wording, the same report, the same structure, apart from the child's names changed. Be careful with those experts because, of course, those are not the kind of experts, if you're for parents, will necessarily be open or as open as you want them to be on the face of it as looking for explanations, because they have a standard way of looking at things and they tend to stick to it. And that's my personal experience I'm sharing with you. Others will no doubt tell me you've had other experiences, and that's fine too. Don't be afraid to challenge the experts. If your client has put something forward, always challenge it. Always challenge it first in questions, so you can show the judge that you've done that, because we're moving to a culture where you have to justify calling the experts now, so it's important that you do that. But also, if your client has demonstrated a mechanism to you, I would say you should be showing the expert that mechanism to get them to comment on it. Otherwise, it will leave your client in difficulty if you simply ask a question on paper about that. Make sure you read the medical records, because often that will show certain patterns that experts can miss. And make sure that you make the effort to read around injuries. So for instance, in babies and when they have suffered fractures, you want to look at things like prematurity, osteopenia in babies and read around that, because that might be quite useful to challenge your experts on. Interveners. So the local authority sometimes has to bring in interveners. That's when a parent is not the only person or persons who might have injured a child. And if they do, these people have to come into the proceedings to defend themselves. It's a balancing exercise as to whether you bring them in as full parties or whether you bring them in intervener status. If, for instance, Granny is the carer of the child, or principally the carer of the child and wishes to care long term, so it's not just, she's not just coming in to defend herself, she has a real role to play in that proceedings in terms of not just defending herself, but welfare. You might want to think about, well, actually, does she need to be a full party? If, for instance, though, someone like a stepdad or a stepmom is only coming in to defend themselves against the allegations that they could have caused the injuries and otherwise not going to be involved, the general trend is to intervene them, which means that they are allowed to be involved up to and including any trial where the allegations will be looked at, and they are allowed to have limited papers where issues of confidentiality have to be managed very sensitively. If you're a full party, you're entitled to all the papers. If you're an intervener, you're only entitled to papers that are relevant to what you're intervening for. So, i.e., you're intervening to defend yourself against allegations, you get any information that is relevant to the allegations only. So I've given you some case law there, but that is the general rule of when people should come in as interveners and how you can tell the difference between party status and interveners generally. Let's move on. So we've looked at the law, we've looked at quite a bit of law, and I hope that most of that hasn't taken you by surprise. I just want to recap then very quickly, just reflecting on the law. Where are we at? So let's just break down very quickly from when an injury will be discovered up to when we go to court. Social services come across an injury, child's presented at hospital and has been noted, for instance, to have fractures. And the very first question that they will come across is, should proceedings be issued? If you are for a local authority, you always have to consider that issue. And there are horror stories, even in my own career, where I've worked with local authorities where they had a situation where a child suffered injuries 2 years ago and they've kept it in PLO and they've just been disrupting this family and keeping them apart on the Section 20 whilst they, in essence, figure out what to do next. If it is the kind of case where you need to know what will happen before you could proceed, what has happened before you could proceed, if it is the kind of case where the family is going to be obstructed and intervened with until you know if something sinister has gone on or not, if you need clarity to complete further risk assessments, issue. Do not drag your feet. This is not a PLO case at that point, issue. When you do issue, if you go to court, one of the first issues you have to think about is if interim removal is necessary. Now, it is not always necessary. I think local authorities think because a child's been injured, we have to remove the child and their siblings from the family. You don't necessarily have to. So, for instance, there may be cases where Granny can move into the home, or Granny and Granddad can move into the home and Mum and Dad can be under constant supervision in the home, but that the child could otherwise be back in the family unit with them. In those cases, supervision might be enough. You might not need removal. You might just want an interim supervision order or an interim care order to monitor the situation with a safety plan. Make sure that viabilities are conducted urgently because, of course, we need to know if there are other options for the family. And when you do the viabilities, and I speak to both representatives of the local authority and the parents and the guardian with this one, you will come across those family members who say, I don't believe it. I don't think my sister could have injured this child. Often local authorities will just rule that person out instantly. They don't believe it, and therefore they can't safeguard the child. It is not that simple. And I would ask, if you particularly represent the guardian, you think about challenging that, because they might be the kind of person who themselves have had 6 children, never had social services involvement, respectable member of the community, no criminal record, can absolutely raise a child and keep it safe. It is not unusual for people to say, I don't believe it, but actually still be able to safeguard, still be able to work with professionals, still be able to follow a safety plan. And so it is the kind of thing that if that arises, be ready to challenge it. Be ready to get that person involved, get the statement from them, to speak to them, for the guardian to speak to them to see if they'd follow a safety plan, because it might be the better option than placing a child into foster care. And likewise, when the social worker will prepare the SWET, and when the guardian and the parents' representatives will look at the information to see if removal is needed for every child, remember that the risk to children is different for every child. So, for instance, a newborn baby who has a fractured rib or a fractured ribs, there is a risk to that child. Obviously, there's a risk to that child at the start of the case. But is there a risk to the other child who is 12 in the family at the time? Does the 12-year-old need to be removed? Well, probably not, because A, the child is old enough to speak up. B, there can be safety in planning. C, the child is seen at school for 5 days a week. D, the child can speak to the social worker themselves. And E, nothing's happened with that child in 12 years. So it must be the case that the local authority and the social worker is alive to. She needs to address the risk to each child individually. Removal for one child might not be necessary and proportionate for another. And again, for the parents and the guardian, you will want to champion those causes. Likewise, with contact, local authorities can often say 3 hours a week, 1.5 hours a week. If there's a family member who can supervise, if there's a family situation that has been put in place, consider the issue of whether the parents could go to the family's home. Consider the issue of if the family member would be willing to promote more contact on the supervision. Does that mean that it needs to be such limited contact? I have a case at the moment where granny's caring for the child. The parents have moved out of the home, but to make sure that the children who have remained in the home with granny don't realize what's going on and to normalize it as much as possible. The parents come in at 7 o'clock every morning and stay there all day and go home at 8 o'clock at night when the children are put to bed. And so the children don't actually know that the parents don't live in the home, but that is being managed by the family members fully supervising and a safety plan being in place. And that's worked great. That's worked great for months now. So just be conscious that there could be creative ways around having to severely interfere with families in the way that we would conventionally think that we could and should. Social workers. So social workers, then, you've brought it to court, you've issued the proceedings. We need the evidence, and we've gone through already a lot of what they should do and the reasons why, the importance of primary evidence, the importance of proving your case. Remember to get full Children Act statements, clear notes of accounts taken, because you need it for the chronology that you're going to build. Statements from people spoken to, follow up from leads. And in particular, what I mean by that is when the police disclosure comes in, have a sneaky look at that log, because often the police speak to members of the community, neighbours, and there's something that we otherwise don't know about, and it's in there. So the neighbour reports the night of the injury, they were screaming and shouting in the house. That's the only place we find that. You may wish to think about, do we need a statement from that neighbour? Is that going to be relevant evidence? Because a social worker might not realise that. So again, gather that information and do a family assessment. Get a context to this family to understand their background, the pressures on them, and where they're at. Again, that might be relevant later on. And how best do you present the case then? Remember your primary evidence, gather it. Consider very early on the need for interveners to become involved. And I've included there the case of HDH&C, and which in essence tells you the test of Oxfordshire, which is around, actually, do you need a finding of fact hearing or a composite? Do you need to litigate the injuries in the case? So there are cases that we come to court with and we think something really serious has happened. The child has alleged physical abuse, for instance. But when we get through the case, we realize actually there are lots of other reasons why this child couldn't go back home. There's domestic abuse, there's mental health issues, there's substance misuse. You might want to think about, in those cases, is it actually proportionate to litigate the injuries and the inflicted injuries, to find out who has done what and if it is inflicted. And HDH&C was a case in 21 that basically said Oxfordshire from 2005 remains good law. And Oxfordshire sets out the test to be applied when you look at what is proportionate to litigate. So you look at things like the interests of the child, the time that the investigation will take place, likely costs to the public fund, evidential result, necessity or otherwise of the investigation, impact of the findings, prospects of a fair trial, justice in the case. And you want to make sure that you revisit that and think very carefully, if it is more than a single issue case, if there are lots of issues in the case, do you actually need to litigate these things? Because there may well be cases where it's horrific what's happened, but it will not make a difference for these children if it's litigated, and there's no point delaying proceedings to do that. So, how best to present the case and challenge the case? Well, I think we've talked about all this, haven't we? How to gather your evidence and build your chronology. What I want to talk to you about is non-accidental injury as a term. One thing to flag is that the medical professionals often call it non-accidental injury. They always file reports that say non-accidental injury. There has been case law, as is there and as on your handout, that says that actually that term makes no sense. The medics might use it, but what we say is actually it is an inflicted injury. It's been inflicted on the child. It's not an accidental injury, it's been inflicted. That is important because infliction has different elements to it. If you're for the local authority, you want to clarify what you're going for. Do you have the evidence to say that it was deliberately inflicted, which is a very sinister thing, or do you have to settle for negligence or recklessness, for instance? Likewise, if you're for a parent and you can see that it is inevitable that your client is going to be found to have injured a child, might you want to be suggesting that actually, if they do it, it clearly was recklessness or negligence, and they can be worked with to overcome that. It's important to know that there are different types of inflictions, and it's important to put the local authority to proof as to exactly which one it's going for, because if you're for the parent or the guardian, that is very important for risk assessment later on. Someone deliberately inflicting injury on a child is very different than someone who is negligent or reckless because they're young and naive and don't know how to look after a child. And then finally, you'll be pleased to know, what time is it? Oh, we're just there. I gave you a list of case law that you will want to look at in your own time. I'm not going to go through it all with you now, and I've given you a summary on the handout of all of the cases. Just a couple of the cases I want to flag for you. The first one is T, finding of fact. That was a case, that was the case that we were talking about earlier. No, it wasn't. That was the case where a DDJ had made certain findings, very serious findings of sexual abuse. And for those of you who don't know, I'll tell you, if a district judge is appealed in care proceedings, they go up to a circuit judge first. And then if the circuit judge is appealed, it goes to the Court of Appeal. The appeal went up to the circuit bench to be considered, and the circuit judge decided that he was going to overturn the findings because he Googled it and realized that this child who was saying that they were sexually abused in a car on the street, well, the street's too narrow. And if they were sexually abused in that car for 3 years, someone would have seen it. It's the kind of thing that people are walking by the car all the time. Therefore, the findings couldn't stand, and the judge overturned it. In the Court of Appeal, he was very heavily criticised for doing that. And what the Court of Appeal said is, it is wrong for any judge to carry out his own investigations, and doubly wrong for a judge to do so on appeal, when the issue is whether the judge at first instance was wrong. So that judge was really criticised for doing his own investigations. And the lesson from it, I think, is that judges have to survey the whole canvas of evidence. They have to look at the evidence in the case only. And if they do that and they give a judgment, the Court of Appeal will be very hesitant to overturn it and will stop other judges overturning it unless they have proper reasons to do so. Another one of the cases I want to flag to is PHL. This is a really useful case because often what we do is we get mobile phone extraction, and by that I mean analysis, and we have these huge questions that arise. Oh, what if they were texting other people? Can we have those messages? If they're privacy issues, where does GDPR sit on this? So in that case, it looked at those very issues. And it tried to simplify matters because it said, once the court has determined that the material sought is relevant, prior notice given to third parties who are not part of the proceedings, that, their messages, their voicemails, etc., are going to be probably come in with the disclosure, is unlikely to be needed. In fact, in care proceedings, the local authority lawyer should look at it when the material comes in and redact anything before passing it on to protect third parties. Occasionally, there may be cases where you might still have to give third parties notice because you might need to rely on something that normally would be redacted, for instance, and it's so pivotal in the case, you need to have it served on everyone unredacted. But in the majority of cases, you will not have to give notice. So that's useful to know. That sets out the test for you if you go for mobile phone disclosure and you're worried about GDPR issues. And something else I want to flag to you is the Matrimonial and Family Proceedings Act. This isn't from case law. This is just something that links in with mobile phone disclosure, which is why I put it there. I've had cases before where I've applied for mobile phone disclosure, for instance, on behalf of the guardian or the local authority, and the parent's gone, no, I'm not giving you my phone. And the judge has then gone to me, do I have power to make the parents surrender their phone? Well, the answer is, after much research on my part, which is why I share it with you now to save you time, yes, the court does have that power. It's under the Matrimonial and Family Proceedings Act 1984, Part 4A. And what it says is, where a court is satisfied that a person in England, Wales is likely to be able to give material evidence or produce any document or thing, literally thing, that's what the statute says, likely to be material evidence in proceedings in the court may, if it is satisfied in the public interest to do so, issue a summons requiring the person to attend court, requiring the person to do so at a time and a place, and requiring the person to produce the thing. So if you rely under that statute or that piece of legislation, you can ask the court to issue a summons to make father or mother or granny or whoever attend court and hand over the phone, hand over the thing, because it is in the interest of justice to do so, because you need to have it analysed. So yes, the court does have the power to force people to hand over their mobile phones for analysis. Any other cases? So I'm not going to go through all the cases with you. I'm just going to flag the ones that I think are really important for you to note. Re-M is the last one I want to flag to you, which is from 2021. There is a private law case, but it is relevant because it raises the point I was discussing earlier about vulnerable people. We will work with those parents who have learning difficulties and disabilities. We will come across those parents who make serious allegations of domestic abuse and who will need protecting and special measures. And that was a private law case, but fundamentally, Mrs. Justice Judd overturned findings made against a mother. And she did that because there had not been, in her view, proper consideration of the rules, the Practice Direction 3A and 3AA, which is the vulnerable witness provisions. The court hadn't considered it properly, the court hadn't applied it properly during a finding of fact hearing, and therefore the matter had to be reconsidered. I flag that because if you have a case that arises where someone is incredibly vulnerable and you are pursuing findings against them, do have a read of that case, private law or public law. The family procedure rules and the provisions for vulnerable witnesses are the same, and you want to make sure that you follow those and put those measures in place to avoid an appeal coming later on. No one likes an appeal, it delays everything. So those are the ones from the updated case law I wanted to flag to you. Let's look at what we've considered today then. We've considered the relevant law, so we had a good recap on the law. We looked at the structure of these cases involving inflicted injuries, when they come to court, when they should come to court, and what you should do when they're in court to challenge the evidence and to gather the evidence. And we looked at how best you can support your clients, in particular with the recent case law and what it says there. I hope that has been helpful to you. Are there any questions? But I've just realised you can't ask questions on this, can you? I don't think. If you can, please pop some in a chat somewhere. I'll try and find a chat now. But otherwise, thank you for attending. Thank you for listening. This will also be recorded and posted, so you can have it at a later date. I'm just looking to see if my clerk is there. Francine, are you there, or Lee? Oh, there's a question. Oh, no, it's just someone saying thank you. Thank you, Shazia. Does anyone have any other questions? You can post it in the chat. No questions by the looks of it. In which case, thank you for attending, everyone. Have a good evening.